Well, good afternoon, good morning, and good evening to everyone joining us from around the world. And welcome to join our Hague System webinar, the aim of which is to give you an overview of how you can benefit from the Hague system. Today's webinar will be held in a panel discussion format. Joining me in the discussion will be Benoit Tardi from the Southeast Asia, Giovanna Girardi from Latin America, Andrea Iori from Africa, Elliot Papagiorgio from China IP SME Helpdesk, and Iker Ayerbi from SMEA will deliver welcoming remarks to us as well. We will have a panel discussion, and after the panel discussion, we will have a Q&A box. But before we will start with the webinar, I know you all saw this amazing video about what the help desk does, but just to give you also a very brief overview of what the international IP help desks do and how you can benefit from the services available. The international IP help desks are there to support European small and medium-sized enterprises with the protection of intellectual property rights when you internationalize to foreign markets. We do have a quite big family of help desks, which has grown over the years. We have Latin America, India, China, Southeast Asia, Europe, and Africa IP SME Helpdesks. All the help desks provide very similar services. It's just the geographical coverage that differs. The core service of the help desks is the inquiry helpline, whereby companies can contact the help desks and ask any intellectual property rights related questions and do receive a reply within 3 working days. Apart from just writing to us, you can also request a one-on-one consultation session to talk to DIA IP business advisors, most of whom you will meet already here today. Those consultation sessions are confidential and they're also completely free of charge, as are all the services of the China IP SME Helpdesk. We also organize trainings, all over Europe, as well as the target regions where the help desks are located. And through our website here, you can see the landing profile page from which you can then click to each individual website, which then provide you with all the information that you need to know about IP protection in the specific region. Apart, all the websites also accommodate a blog. So if you want to keep yourself most up to date in the recent developments, then you're welcome to check that out as well. You'll see our social media handles on the screen. So please do reach out to us, keep in contact. So if you move on to the next page here, you can see for contact our contact addresses, but again, you don't need to write all of this down. It's just from the landing page. If you just use our website and enter from the landing page, then you are able to find all of our contact details there as well. So let's go on to today's webinar. So we will have, after I've done talking, we will have welcoming remarks from Iker Ayerbi from SMEA. After that, we will look into the importance of design protection, and then we will discuss the Hague system with a country-specific overview and some case studies shared by our experts. And we will finish the webinar with a Q&A session where you can ask us any questions. But of course, you don't have to keep your questions until the very end. So if there's a question, you can already use the Q&A box and to write your question there so that we can read it out at the end of the webinar and then respond to you and have a discussion on design protection internationally. So moving on the 6th of November, the World Intellectual Property Organization commemorated the 100th anniversary of the Hague System. So 100 years ago, from the small 11 founding member organization, a bigger system, including now almost 100 members, was born to facilitate design protection. And as more and more countries in the regions of China, of Southeast Asia, of Latin America are joining, the Hague System, the International IP Helpdesks, created a guide on how to use the Hague System, how it works. So this is also what we will be discussing at this webinar today. We will discuss what you can find within the guide, and we will go through some of the key aspects that you should remember when you start using or when you start filing your design internationally, and you might consider whether to do it through the Hague System or not. So we try to be very practical at today's webinar. So, and of course, from this link, you can download the guide itself and read it. Now, without any further ado, let me welcome Aiker Ayerbi from SMEA for some welcoming words today. Aiker, the floor is yours.
Thank you. Thank you very much, Helika, for this introduction, for the overview of what the International IP SME Helpdesk do. Also to all the other colleagues of the IP Helpdesk, my congratulations for the work that you are doing and the quality of the services that you are providing. I will be very short because the topic of today I think is really interesting, and I would like to give you enough time to discuss it. So basically, I would like to welcome on behalf of the European Commission to all participants to this session. Your participation shows that how relevant this international design protection has become for European SMEs to really compete in global markets. So my name is Iker Ayerbe. As Helika said, I work in SMEA, a different acronym, but it's the executive agency of the European Commission for SMEs, implementing these services of the IP Helpdesk and many other initiatives that mainly focus on the competitiveness and internationalization of SMEs. I wanted to just maybe contribute a little bit to what Helika said about the IP Helpdesk. So we have been supporting this initiative and running this initiative for more than 15 years already, since the first one started in 2008. So through these years, the helpdesk has supported thousands of SMEs navigating the IP issues that usually are not the main thing to have in mind when you are running a business. And sometimes you find out that when you are trying to internationalize, some issues are to be really taken care of, and sometimes those are due in the last moment. So the helpers are here to provide you assistance on understanding a little bit how to protect, how to manage, how to enforce your IP rights when you are doing business in foreign markets. So our message today is that the Commission remains very clear, is to provide you free, confidential, that is very important, and first-line IP support. So you have seen all the different services that they provide. Please don't hesitate to contact them, to collaborate with them, to be in touch with them, because they are very helpful and they will really support the implementation of your initiatives and the growth of your companies. So with this, that's all on my side. So thank you again for being here today, and I wish you a very fruitful session. Thank you very much.
Thank you very much, Iker, for highlighting the importance of the IP SME help desk, as well as highlighting the importance of design protection. And design happens to be one of the more overlooked areas of IP. Especially by European SMEs, and especially when internationalizing to foreign markets. Everyone understands the importance of trademark, the importance of patent, quite immediately when internationalizing the foreign markets, but design does receive maybe a little less attention. And it might also be that it's not always very evident what design is. So before we are starting to discuss the Hague System, let's focus also on what is design, what are design rights, how we can protect them, and why we should protect them. So when we're talking about design, we are talking about the overall appearance or the visible aspects of a product, encompassing the elements such as the shape, the configuration pattern, or color, or ornamentation, or the combination of all of those aspects that I just mentioned. And design doesn't have to look good. When we hear design in connection with fashion, or fashion and design and creative industries, but we can find design everywhere, even with the consumer, all of the consumer products. So think about your product packaging. Maybe you do have a special packaging that distinguishes you from your competitors and is appealing to the consumers and is attracting the consumers to buy it. So all everyday consumer products, electronics, appliances, all can have design, and all of those can benefit from the design protection because design is usually the easy aspect to copy, as opposed to the technology that is underneath that design. And it is very easy, therefore, to pass off the counterfeits as being the genuine product, and to confuse the consumers at the market, and also cause harm to your company if that should happen. So design, in fact, is a very important area to consider when planning to internationalize. If you do register your design, if you choose to protect your design internationally, it also gives you the opportunity to fight against counterfeit and infringement. So if anyone copies your design, you are the owner of the design and are now in the position of taking action against the infringements. It also allows you to sell or license your design in foreign markets, for example, and it also increases or can increase the value of your product, as investors might be attracted by your design, and that is something that helps you to negotiate maybe a better position also with the investors. So as we now understand that it is important to protect design, let's discuss what can be protected. Now, in general, we can protect the appearance of the product. However, the exact rules and regulations of what can be protected may differ a little bit regionally or based on different countries. So in general, it is the appearance. It is usually the requirement of a novelty, so that the design has not been made public before its registration, and also industrial applicability, meaning that it is reproducible. But let's discuss some of the different aspects that we would have to know when considering design, or what you would have to know when considering design protection in different regions. So let's start with Southeast Asia. And Benoit, could you please let us know what are the notable aspects that SMEs should know about when considering design protection in Southeast Asia. Benoit, please.
Yeah, thanks. It's quite difficult to, let's say, talk about design without seeing any visuals or anything, because it's quite difficult in terms of understanding. But for Southeast Asia, we have 10 countries, a region which is not harmonized. We have principle of civil law, principle of common law, no regional system, and this applies to all IP rights. So it's a bit complicated, but also why we are here to support SMEs to understand a bit more, let's say, the region. We only have so far 4 countries who joined a Hague System. So Brunei, Cambodia, Singapore, and Vietnam. Maybe more to join. It's been discussed with 4 other countries, but so far only 4. We also do have some local specificities. I will just briefly mention some. So maybe some of you know that it's possible to protect only parts of a design, and this is called partial design. And weirdly, strangely, some countries do not allow this. And the perfect example is Vietnam. So you cannot protect partial design in Vietnam. Second point, novelty. Novelty requirements, you can have what we call absolute novelty, meaning that you will take a large range of prior art, any design that were made public before a specific date, either from one country or worldwide. Let's say that most of the countries of Southeast Asia follow absolute novelty, but you have a couple of countries, Indonesia, Philippines, Thailand, Vietnam, that do not have, let's say, this vision. Then we have the duration of protection that will vary. So you may be surprised, but it goes from 10 years to 25 years, 25 years being like in the EU, 25 years is Malaysia. We have 10 years, it's for the moment Thailand and Indonesia. And let's say in between 15 years, this is the common thing that you will find, the term of protection for Southeast Asian countries. What is nice to know and to follow is that there is currently kind of a harmonization, and you may see some changes. Countries with only 10 years of protection switching to 15 years, or maybe switching even to 25, like Malaysia and the EU.
Thank you, Benoit. So we can see that in Southeast Asia, the design rights are also still quite evolving, as you're saying, that some is switching from 15 to 25 or some the other way around. So let's see what are some of the specificities of China to know. So Elliot, please.
Yes, so I think Benoit gave us an excellent introduction. People think about Southeast Asia as being a homogeneous region, and it's not really. So as far as China is concerned, of course, it's the big fish. It's the biggest trading partner for most of the countries in Southeast Asia, and indeed for many in Europe. So the key things about the Chinese design system, as Benoit already touched base on, as of June 2021, China has expanded the duration for the protection of designs from 10 to 15 years, as foreshadowed by Benoit. Also, China had made a number of changes which would enable international filing to be made a little bit easier. And I think some of it was with a view of its ascendance in February 2022 to the Hague design system. And one of them was the way that it accepts drawings. Before then in China, line drawings to allow for, like dotted lines to allow for the protection of partial designs. In other words, you would dotted line the parts that you are not seeking protection for. That was not permitted, or that was not recognized well or enforceable. And in this particular case, China had changed that explicitly in the guidelines. You will hear the term, by the way, in China, design patent. And that has to do with the fact that China has included designs in the patent law. So you've got invention patents, or what you call patents in Europe. You've got something called utility model patents, which are like these utility models, or the Germans would call it Gebrauchsmuster, which originated in Germany about 150 years ago. And you also have design patents because it's part of the law. They're still registered designs the way we know them in Europe, but they call them that because, of course, everything under the patent law is considered to be a patent. Now, a couple of peculiarities on the Chinese system that should be noted is in China, you can add up to 1,000 words when you are filing a design locally. And this is something we can discuss later on whether that makes sense. And Benoit may know that other countries that do similar things. We generally would say that you do not add any text. SMEs particularly should not try to limit or put any words in because it would limit the scope of their design. You know, they talk about a picture being worth 1,000 words, but 5 words can limit the scope of your picture. So in other words, apart from the title, one would leave those 1,000 words, which you can provide for as blank. The other thing that's very interesting, again, it sort of overlaps with what Benoit was saying, was that you can protect partial designs. And in China, the test is always, does the design or the thing being protected by the design have a separate life? So in other words, in practical terms, because it's great to talk about a separate life, but what does it mean? Well, it basically means that if that product is sold separately, which has got 2 advantages in China. Number one, it means that you could use designs to protect spare parts, because there aren't the sort of line of cases we're familiar with in other parts of the world where spare parts must fit exceptions. They don't exist yet in China. So it means that you can protect spare parts. Of course, as Benoit said, the application of absolute novelty also applies in China, and we'll come to a point in that which then overlaps with the Hague System later on in our discussion. But one more important thing that I think is really quite key on the design system in China is that you can also protect internal parts. So in many countries, you have the requirement, and Benoit may know about other countries in the region, that it must be externally visible, right? In other words, that you must have a design aspect that's externally visible. And if you want to, for example, protect an internal part, that's only possible if the outside corpus is transparent. Well, in China, that is not a requirement. The design does not have to be externally visible when applied, when used. So in other words, there's a greater scope for protecting those as well. Just another couple of brief points, really quite important in this case, is that China does not recognize a grace period. So this ties into what Benoit said. There is absolute novelty, and you don't have those 6 months that you have in many countries, including in the EU, that, oh, we were at the trade fair and oops, we displayed it, or oops, we filed it on our LinkedIn page or WhatsApp, WeChat, our own website, and we've got now 6 months to file it. No, you don't have that. And the Hague system doesn't change that fundamentally. So be aware that the point of absolute novelty that Benoit mentioned is especially strict in China. In other words, if you published it anyway and somebody captured that publication, there's a good chance that your design may be weak.
Thank you, Elliot, for this very detailed overview of design protection in China. But it was also easier because we were talking about one region. So let's go to a region with
Benoit introduced it really well. So thank you, Benoit.
Even more countries involved now. So Giovanna, could you please tell us about some specifics about Latin America?
Hard to talk about anything new now. But well, when we are considering Latin America, we are considering 33 different jurisdictions. That means we're talking about 33 different laws, 33 different regulations that allow for the ownership and exclusivity use that these rights grant to the owners, no? So to me, this means that we have to look into specifically the country we have commercial interest. There's no way around it, because there'll be differences into the requirements for registration and requirements to gain ownership and rights over those designs. There'll be differences in duration, like Benoit introduced in the region. There are countries where you can have protection for 15 years. There are countries where the initial duration is 3 years, then you can renew it for periods of 5 years. There are countries where you can renew up to 25 years. So it's different. It's different, and these differences need to be taken into account. What remains equal is the type of right you're getting from the registration. Yeah, you're getting exclusive rights. Those rights that you want, that your competitors want. They enable your commercial relationships. They enable consumption. They enable your consumer to be interested in your offering, no? So that's what remain important. And the other thing that you may find differences is the examination process will be different. The examination process in all these countries will be different. Some countries you have a thorough examination. That means you have formal and substantive examination, and that means that when the right is granted, when the design is granted, is obviously a strong right that will be hard to be challenged. But in many countries, substantive examination is not performed unless the applicant requests the substantive examination. And where you do not require substantive examination, you write maybe not as strong in the end. So in substantive examination, what countries are assessing is exactly the requirements, the legal requirements we discussed, what you introduced at the beginning, Elika, novelty, external appearance, which is external appearance again is something we will find that will differ from country to country. Also in Latin America, some countries will the requirement is the design has to be an external aesthetic feature either of the product or its packaging, but it's an external feature. So internal parts cannot benefit from design rights. But that will vary from country to country. Each country will have their own word on design rights is about. So yeah, requirements, duration, the process will differ, but the rights you gain in the end will be similar throughout the region. And these rights will enable you to create value for the company, but not only to create value, economic value through the commercial relationships and the consumption itself, but also enable you to defend your interests, your business interests in the region. So very important to say that in most of the countries in Latin America, there is no rights to non-registered designs. The advent of a non-registered design that we do have in Europe does not exist in nearly all the region.
Thank you very much, Giovanna. You're talking about 33 countries with 33 different laws and regulations. But in Africa, we have even more countries. So I'm assuming also even more laws and regulations. But in Africa, we have, in addition, also some intellectual property rights organizations or systems. So Andrea, tell us about how the IP protection or the design protection specificities in Africa.
Thank you, Elika. Thanks for the introduction. As you said, Africa is a very complex environment, especially because there are more than 50 countries. In general, designs are very well recognized, but of course, routes of protection vary considerably depending on these complexities. The good point is that there are regional organizations on the continent. One of them is the African Regional Intellectual Property Organization, called ARIPOSO in the acronym, that serves mainly English-speaking countries, and the OAPI, Organisation Africaine de la Propriété Intellectuelle, that covers 17 countries, and then through a single application can automatically grant protection all the member states. But apart from those, it's important to remember that big economies such as South Africa, Nigeria, and Egypt are not part of a regional organization. So in this case, a national filing system is mandatory for companies that want to apply. Of course, the Hague System gives a big hand, let's say, to companies, because of these 50 countries, around 30 in Africa are part of the Hague System. 17 of them are part of OAPI, so 17 pigeons with one stone, let's say. And there are also others like Botswana, Egypt, Ghana, Morocco, Namibia, Rwanda, Sao Tome, and Tunisia are also members of the system. In terms of duration, in Africa, it's between 5 and 10 years renewable. And another point that is important to remember is the concept of partial design protection that was also mentioned by other speakers. Many African jurisdictions allow you to protect just a part of a product, like South Africa, Kenya, to mention some of them, Morocco as well, while others, and big economies like Nigeria, only do not recognize partial protection. In terms of novelty, most African countries apply the rule of absolute novelty, meaning that the design must be new worldwide at the time of filing. And I think also other colleagues mentioned the grace period. In some cases, like South Africa, again, big economy, or Kenya, Botswana, there is a 6 months grace period, while OAPI and Morocco, for example, allow for a 12 months grace period in certain cases. By contrast, Nigeria is the most strict, where no grace period is allowed. So, in short, it's a big patchwork, of course, but SMEs can, let's say, use different strategies to protect their designs by assessing if the Hague system is available, or going national, or through regional organizations. So, very shortly, that was my point for that.
I think we may have just been caught briefly behind a great firewall. Helika is, I think, properly being cut off, maybe by Mr. Shi personally. I don't think we want that transcribed, Andrzej, so maybe we will delete that part of my comments. Otherwise, I will be going where Helika's gone. Jokes aside, shall we briefly, Benoit, Giovanna, and Andrea, shall we sort of keep going in the meantime with a sort of plan of how we want to go through that until Helika rejoins us? Helika, interrupt me anytime. Okay, good. So I think what we want to be discussing is we are here to talk about the Hague system and how it's implemented. And let's start perhaps most east if we can. And I guess from that perspective, Benoit, just to give a bit of an overview and recognizing that you have yourself and Giovanna and Andre in an increasing order challenged with a number of countries, and I've got it easiest. So I'll let you guys proceed first. Because this is an area that people are probably least familiar with, and then I can sort of round off with China. So Benoit, would you start us off with how the Hague system applies and in which countries and how it's relevant in your region?
Okay. Sorry, there's a fly coming in. Yeah, sure. Well, first of all, I think maybe it would be good to tell people if it's worth or not worth using the Hague, because you always have, like for all international treaties, you have pros and cons of using it, and then it's really up to the company and companies to decide. So maybe I can just briefly start with this. Basically, among the pros, the first part is really important, and we cannot hear Helika. The screen is frozen, but we can just see your messages on the chat. So we keep going while you're trying to fix the issue. So Hague, it's a beautiful system. It's a simple filing process. Basically, you have one application, several official languages, and you pay one set of fees in one currency. It's a centralized system online. It's managed by WIPO, a World Interpropriety Organization. You can protect up to 99 countries, and you can manage everything from filing to renewing your registration, to even changing some information about, let's say, the applicant, the owner, the address, things like this. Then it's supposed also to save you costs and also time, meaning costs, basically transaction fees, and also some local agent fees at the starting point, because it's an international application process. And let's say the last one, maybe this we can all discuss because it might be a bit different from country or region to region, is also you can control the publication. When will your application be published? And when will third parties be aware of your design application? These were like the pros. For the cons, let's say that you have a limited coverage if you compare to other international treaties. Only 99 countries for the moment. It keeps on raising up. We have domestic requirements, for example, in Southeast Asia. But usually, let's say that there are no substantive requirements. I heard, for example, Giovanna was saying that you can sometimes request this specific substantive examination. So like this, you have a stronger right. And let's say the last part is there may be some additional requirements for some countries, meaning that you have like an increased burden of paperwork, or let's say of documents to submit during your application. So basically, this is a case-on-case basis for countries. And I see that we have Erika back on track.
Hey, can you guys hear me and see me now?
Yes.
Yeah.
Apologies for this. Sometimes the connection in China can unfortunately be bad. Well, Elliot seems to be in a better place than I am, because he is also based in China, but apparently he's not dropping. And Elliot, thank you very much for stepping in quickly and keeping the webinar alive. So while I was away, I understand that we now discussed what the Hague system is and how it can help you. However, many of our listeners might very well be aware of different international filing routes, such as the Madrid system and such as the PCT, for example. So Elliot, maybe you can explain to us the difference between the Hague system and then Madrid and PCT.
Ooh, you have really sort of, that was what we call a hospital pass. That's what a lot of big rugby players are heading in your way, and you're getting the ball and you know what's going to happen next. Sure. Look, I think there are some key there's some key differences, and if you're looking at the Madrid system, obviously relates to trademarks, and we're looking at PCT, it looks at patent filing. But I think the really key differences is the sort of duration that you've got to extend, right? And if you're talking about trying to keep a priority under a Madrid system, one of them is that you file within 12 months. The Paris Convention allows you to do the same. And the Madrid system, the biggest advantage, I think, of the Madrid system is, again, low cost and centralized filing, and really ease with the way that you proceed through it. When you're looking at the PCT system with patents, of course, that's very different, because the PCT system, if you opt for it, gives you a much, much longer time than Paris, right? The Paris Convention, again, gives you 12 months, whereas the PCT system, that's the Patent Cooperation Treaty system, it really is, again, like using a central filing box, but they're up to 30 months, which is particularly important for SMEs, because the PCT system allows you a later decision on which countries you want to activate that privilege in, right? So and then you've got a grace period of 1 or 2 months afterwards. So for example, for China, it's the 30 months according to PCT, plus another 2 months if you miss that deadline. But don't rely on that deadline as it's just good to have nicely when somebody thinks they missed the 30 months, you get the extra 2. Now, the Hague system, I think that from the perspective of IP rights, the Hague system's got really sort of elements of both, but mainly if we were to liken it, it's so closer to the Madrid system in that it enables you to take your initial filing, and of course you do not need to have a national filing under the Hague system, which is something that you need under Madrid. You don't need a national filing. You can directly activate the Hague system and then decide which countries you want to file into. That's quite nice, because you do not need to have that situation where you've got, let's say, for example, you've got your Polish filing, you've got your German filing, you've got your Spanish filing, and that needs to be the first anchor before you can then use the Madrid system. And in the Hague, you don't need to do that. That I think is the biggest advantage. Then, of course, the other advantages are where you've got more congruence, which is that you've got a central organization that you're dealing with. There are cost saving, obviously. Unless you have, which is the same under each system, unless you have a block or a rejection, in which case you're going to then still have to go take some national steps. But the biggest advantage really is that you don't have to have that national filing, which you do require under the Madrid system. Again, compared to the PCT system, you're looking at something very different because the PCT is really meant for patent invention, for innovation type filing, patents or utility models, but not for design. So the Hague system is really reserved for designs, and it does carry some advantage, especially for SMEs.
Thank you, Elliot. It seems that the Hague system is then taking the best parts from the Madrid and then from the PCT. But let's discuss the pros and cons of using the Hague system. So, Benoit,
So
maybe you could let us know.
Basically, while you were away, I was too excited to talk about Hague system, so I already shared this part.
Yeah, in fact, if we extend it perhaps to the Chinese perspective briefly, so to lead on from what Benoit was going to say on it, or what he did say about it, there's 2 or 3 elements which we need to be aware of. And one of them is that different countries, and Benoit and Joanna and Andrea, I will pass over to them then to mention from their context. But one of the challenges in relation to the Chinese system is it's not being used that well yet, right? So we're talking February 2022. Takes a while till we have enough track record. You need to make sure that you consult and you make sure you still meet the CNIPA, which is China's intellectual property office, that you meet their requirements to make sure you have a smooth progress through it, right? So that's one of the challenges. There are also other challenges which may also be reflected in other countries. For example, if you have a multi-design filing, how do you split it if there's a partial problem with any one of those? There are other advantages and disadvantages, which I think we should come back to when we talk about the practical use. But let's pass it on to one of the other jurisdictions, because I'm sure there as well, they have a longer track record in some countries with the use of the Hague system. China has a relatively short one.
Indeed, but thank you Elliot for enlightening us about China's challenges with the Hague system, and we will certainly come back to the challenges in our last section. However, let's get a better understanding of how the registration process works. So, Giovanna, could you please enlighten us about the registration process?
Okay, so I think Elliot has given an introduction there on the registration process. If we're using the system, if we're using the Hague system, no, the thing when from the perspective of Latin American countries, this process can only be used in 4 countries. It can only be used in Belize, in Brazil, Jamaica, and Mexico. So the process will be there. You can easily assess this from these countries or to these countries, no, in a way that you formally request the registration of these rights. You request WIPO to manage the request in these countries, no? But the examination and the granting process will be dealt with the national office in those countries as it would if you have applied for directly with the national office. And that means they need to receive your formal application for the right. There will be a formal examination to see if it complies with. And maybe if you requested, for example, in Brazil, you have your substantive examination, but you need to request if you want to. And then within the registration process, we have application, formal examination, substantive examination if it was requested, publication, opposition, and granting, or publication, granting, and opposition. It depends on where you are. Opposition will be at a different time, but all the phases will be within the process, no? Application, formal application, examination, publication, opposition at whatever time, and then granting.
Thank you, Giovanna, for making the process very clear to us. But I guess our listeners are now very interested about how much does it cost them and how long does all of this take. So, Andrea, could you please let us know?
Indeed, Elika, this is one of the frequently asked questions. So In terms of land, of course, based also on what Giovanna's just said, registration process varies from country to country, depends on the local rules, especially if they conduct a substantive examination or not. But in general, we can say that to have an application examined, it takes approximately 6 to 8 weeks. But after this, there are, of course, other timeframes because the designated countries have their own examination periods and typically ranging from 6 to 12 months. And now regarding costs that were also partially mentioned by Benoit earlier, there is one set of official fees that are paid to WIPO. That depends on the number of designs, number of images countries you designate. And these fees include a basic fee that is of 397 Swiss francs, designation fee for each country, publication fee, and sometimes an extra fee if the description of your design is over 100 words. It's important to mention in our guide there's a very useful link that is the Hague System fee calculator that will give you a very good estimate of the costs in advance. So that's very useful to make use of this tool.
Thank you, Andrea. And to add, all of these points that we are discussing today as well are actually included in the guide. So if you are reading and downloading the guide and reading the guide, you will also be able to see that overview. So of course, everyone hopes for a smooth registration process where you file the application, it goes through the examination, and then no one opposes, or if anyone opposes, they do so unsuccessfully. And finally, you will be granted design rights then by the countries that you have chosen to designate. However, what happens if one or some of the countries that you designated chooses to refuse to grant you the rights? So Giovanna, can you let us know what happens then?
Of course, then the process is longer. And in this case, you actually need to appoint a local representative to help you address the issue, because it's the local representative dealing with the local office that will sort whatever or try to sort whatever problem you have there.
Thank you, Giovanna. So it's not the end of the world, it's not the end, but there is still a chance that you might get your design rights granted.
Of course.
Let's now discuss a little bit more about also.
Sorry, Helika, there was a question Alexander had, and I'm not sure if I do not know how to share it with everybody. So Alexander said, Elliot, but China does narrowly recognize 6-month grace period for design displayed at official recognized international exhibition under Paris Convention, correct? The answer is yes and no. So the question here was about whether, and I don't know if you guys can see it. So Alexander Belinsky asked about the question, and it basically relates to the grace period. The answer is, as the Germans would call it, jein, or yes and no, or a good lawyer saying maybe. So you have to be really, really careful about how you go about it. In other words, you need to do you have 3 or 4 steps. One of them is you check that exhibition is actually on China's list as well, including national exhibition as well. So it's not discriminating against foreign exhibitions. There are some that China recognizes. Maybe other countries on this, when we're discussing it, have a similar, or other regions have a similar issue. But China must recognize the international exhibition. So you can't go to the local, I don't know what you call it. Let's call it Frankfurt Hahn exhibition and then say, oh, by the way, we have an exhibition of 50 people, and so it must be on the list that China recognizes in terms of getting the grace period. Then you need to follow the procedure. And I guess this is the same in other regions. You have to register at the exhibition before you display it and show that you've gone through that registration so that you've got this whole documentation. And the same applies, by the way, Alexander, the same applies in China as well. If you want to be displaying it first and a Chinese exhibition and maintain your grace period, you must also, before you display it, go to the organizer, get that certification, And that was a big boo-boo that Land Rover did at one stage with the Evoque. You may remember that there was this whole hoo-ha, Elika, I know you know about it, where the Evoque was copied 1-to-1 in China. And the issue was that Jaguar Land Rover at the time did not, before displaying it at the Guangzhou International Automotive Fair, they did not register it. So they displayed it. And then they filed these designs, and unfortunately in China, they were all rejected as not being, as Benoit said, meeting the absolute novelty requirement. So you must follow a procedure, whether in China or elsewhere, and those procedures good to check locally in China, Alexander, to make sure that that exhibition qualifies. But to be honest with you, would you really want to take that risk of exhibiting? If you've done it, then probably you haven't met the requirements. In other words, you haven't pre-registered, etc. If you've just exhibited it. If you're very, very lucky, it's one that is on China's list of exhibitions. But honestly speaking, if it's ex post facto, it probably doesn't meet the strict formality requirements for a pre-filing or as Benoit would say, a pre-absolute novelty act to be covered by it. So for SMEs, the quick answer is assume absolute novelty. Do not rely on international exhibitions if you can help it.
Thank you, Elliot, for making this clear. Let's take all the other questions after the final discussion that we have, which is in about 15 minutes. We can then discuss more if anyone else has any questions. But what Elliot is highlighting is great that eventually, when you go through the Hague registration process, the eventual decision will be made by the countries that you have designated and that you have chosen. And those decisions will be made according to the laws and regulations applicable in those national countries. So it would be therefore also interesting to explore what should SMEs know about some of the specificities if they decide to go through the Hague system, then to understand what would be some of the specificities that they should understand. Let's start with maybe Latin America. Giovanna, would you enlighten us?
I think is similar to what we have been discussing so far. There's only 4 countries that use the Hague system in Latin America: Belize, Brazil, Jamaica, and Mexico. We need to look at requirements for registration. Yeah, we need to look at the process, how the process is like. We need to look into the duration of the rights. Would differ in the 4 countries, but it will also differ in the whole of the region. So what I recommend here is, like Elliot was saying, do not rely on grace periods. Do not rely on grace periods. Do not rely on maybe having an unregistered right. Okay, we had cases of SMEs, European SMEs, coming to the help desk, telling us, "Oh, I'm launching this collection. There is a monogram. Is a design right? I have an unregistered design right. I'm in negotiations with this company in this country, and they have launched a similar monogram. What rights do I have? None. You have none. You have not registered your design in that country. You have no rights. You cannot claim infringement. And probably, there's a reason why this contract you are negotiating didn't go through, because if you don't have the right that is the object of the contract, if that right doesn't exist in the territory you want it to take effect, the great value, why would anyone want to be in a contractual relationship with you? They will assuming they're undertaking responsibilities, they're undertaking commitments towards you, but the right doesn't even exist. So the first thing and foremost, don't rely on anything that is not tangible in an untangible world.
Thank you, Giovanna, for sharing this very interesting case study. I'm sorry for the company that realized that they did not actually have any rights in that country at all. It's also always an unfortunate situation, but it is great for awareness raising to understand that you really need to register your rights in order to have them protected. But let's look at then Southeast Asia, Benoit. Maybe you could let us know something that companies should keep in mind when using the Hague system and trying to register in Southeast Asia.
Okay, so maybe I will repeat again something, but first read the guide on Hague to understand, contact the help desk, and let's say afterwards, something Giovanni mentioned, yeah, no unregistered rights like in the EU. We have the same here in Southeast Asia. So prepare and file your application. You may have additional documents or information required. This is quite common for Vietnam, for Brunei, for Singapore, for example, in terms of representation, in terms of additional description, in terms of limitation of number of words, as it was mentioned by Elliot. There are some flexibility on some rules. I heard we talk about what we call the deferment of publication. So basically, it's up to 30 months after the application date or priority date. In some countries, this period may be limited. This is the case for Brunei, Cambodia, Vietnam. And just to tell you, in Vietnam, it's 7 months. It's quite short. So you don't have a lot of time to think and to take a decision on where you want to expand the protection. You may need also a local legal representative. This is most of the time the case here in Southeast Asia because you need the address for service. What do we do with the countries that are not part of the Hague? Also a big question, but then you need to prepare separate filings, check, of course, the legislation, the practice of each of the 6 remaining countries of Southeast Asia that are not part of the Hague. And basically, you can reach out to us if you have any question on any countries of these 10, including or not including those of Hague. And yeah, basically, a lot of different rules. It's quite complicated in terms of what you need to prepare, the deadlines. It's a bit like patent also, like you need support. So yeah, be ready.
Thank you, Benoit, for again highlighting the importance of contacting the China IPS or the International IP SME Helpdesks here to receive more information as to how you should file, where you can use the Hague system, and so on. I was wondering, would it be possible to use also OAPI's help and the Arippo's help when using the Hague system and filing applications through the Hague system? Is it possible to designate them maybe? Let's discuss this with Andrea. Andrea, please.
Thank you, Elika. So yes, let's start with maybe with the OAPI. It's pretty convenient to file and designate a country through WIPO and designate a country as an organization OAPI because it covers 17 member states. Let's say that OAPI does not foresee a substantive examination, so only formal one is required. So let's say that you should check on that paperwork is correct rather than assessing the novelty itself of the design. Some points to be considered when you think about African countries is also the sometimes concept of public morality. In certain cases, that is not really for OAPI, but for other countries, it's pretty important. For example, I mentioned Egypt. The design also should comply with these requirements. Another aspect that was also mentioned, and it's very important, is a local representative. because in case IP offices have questions or there's an opposition, then you will definitely need someone who represents you in the country. I'm talking generally, but concretely for cases like Egypt, Morocco, Tunisia, local agents may be required and actually are suggested. Other jurisdictions, and see, the Africa is very, very wide. I can mention, for example, Botswana, that is where rules are simpler just because they don't have substantive examination, while other countries they do have, like Ghana, big economies. And always remember that some big countries like Nigeria and South Africa are not members of the Hague System. So in those cases, you have an option to go for a national application. So, as a general remarks, is that you should, of course, consider the country that you want to designate through the Hague, because they have very different requirements. Some of them they do a more thorough examination. Others they only have formal requirements. Language through WIPO you can apply in 3 languages, but then at national level they operate some countries only in English. So it's recommended to be aware of this aspect, the language requirements. And yeah, in general, the use of local representative is also suggested in certain cases. But being so wide, I recommend that who is interested could address questions separately, and we go into the details, of course, of the case, because being like a plus 50 country continent is going to be difficult to take everything into account in just a few minutes. Thank you.
Of course, if anyone has more detailed questions about any specific African country, then it is best to reach out to the Africa IP SME Helpdesk to receive information, or also to look into our guide. We do have all of this country-specific information included into our guide. It is very simple to use. You can just click on the country, and then a pop-up window opens, and you will be able to find information on the specific country. We have specified whether the country has a substantial examination requirement, whether you need a local representation, and also the times and deadlines.
I think we've lost Helika again. Helika, you back?
So,
okay, we've sort of lost her again. So we'll give her another 30 seconds. Otherwise, Joanna, Andre, Benoit, shall we go on with specialities, peculiarities, things like that? Ups, downs, pros, cons. What do you think? Shall we proceed to that area if we don't hear Helika in a couple of seconds? Elliot, please talk about China specifics. Wow. I love it. This is the second penalty pass. I think I'm not going to survive this rugby match. I will also share it around with everybody else. Helika, I fully understand. I'm good with China specifics. I want to give the other discussions here as well, because some of our listeners may be interested in other regions. Very, very briefly, and let me introduce this, giving Joanna, Benoit, and Andrea a bit of a chance to also marshal their thoughts on these points. There's a few China specifics that are pretty important, and one of them is that if you want to maximize your ability to enforce your designs in China, well, there's 2 or 3. Number one, China does not recognize, and this was something both Joanna and Benoit touched on, and Andrea as well, which is that we do not recognize unregistered designs in China. 0, nada. So in other words, there's nothing where, as Joanna was saying, somebody comes and says, I have this fantastic design. Of course, I have it protected in the EU. That, of course, we at the help desk immediately think, oh, that's great, you have a registered design. Whereas, of course, the issue is that in China, because we don't recognize unregistered designs, and if they have an unregistered design, there's a miscommunication. So for SMEs, the really big message is no unregistered designs in China. No rights whatsoever, unless by registration. Yes, you may be able to rely on copyright, but again, there the big hurdle is the originality. And I'm sure Joanna and Andre and Benoit will see this in their jurisdictions as well. So one big point about China specifics is no unregistered designs. again, maybe Andrea, Benoit, I guess in your regions as well, Joanna already mentioned that in your regions as well, this is something to look out for. Benoit, maybe to you.
Yes, I briefly talk about, sorry, because I'm also checking that we receive new questions on the chat. So yeah, it's most important, the region, Southeast Asia, we have several systems. So maybe the filing, first to file system, and then first to use system derived from common law. So basically, maybe here we can give a glimpse already of information for one of the questions that with common law, you don't need registered rights. You can use special techniques. But the priority, even for these first to use and common law systems, is to register, because you have filing dates, and then you're granted rights, and you have certificates. So it's easier to prove, let's say, an origin of a right. Yeah.
So, but Benoit, in any of the countries of your jurisdiction, just sort of generally speaking, are there formally unregistered rights recorded in the, unregistered designs? Because, the UK also recognizes this passing off, which is common law, but they also have provided for, in the United Kingdom, for example, unregistered design rights. And I know the EU also makes some provision for it. In your region, are there any unregistered design rights per se? No.
No, we do have passing off for a couple of countries, but no.
Passing off. We will come to that. We may come to that. What about Andrea? Africa is a big place, but are there any formal unregistered design rights in any countries?
Well, in general, there's no formal recognition of unregistered design, with the exception of South Africa being a common law country where the passing of the same rules applies. But otherwise, in general, this is not foreseen.
Okay, so this I think I'll pass over to Helike in a moment. Joanna, you already mentioned that this is an issue. You need to unmute yourself. That is an issue with people misunderstanding that. So after you give your comments, maybe Helike can sort of use the contrast, because everyone in the EU assumes that it's de rigueur, unregistered design rights as a formality. They're not. I mean, Andrea, you're right. Benoit, common law passing off. Joanna, what about your region?
It's a no-go. It's a no-go. No, guys, don't rely. Is a sensitive. Again, it's not only a matter of registration and ownership. It's a matter of you need those rights. You need IP, not only designs, but the value of designs, the value of trademarks, the value of patents, the value of copyright is in the commercial relationships you're going to establish.
Right.
What is the value an unregistered design will bring you?
Not much.
So
I mean,
we need to think the why. We need to think Simon Sinek, Simon Sinek in your why. Start with the why.
I think it brings us it brings us full circle to Helike for her to take over again, which is, why do we have the Hague System? To make the registration easier, right?
Exactly.
And therefore it's to encourage what we're all saying. So we're not trying to put anybody off. Hey, you still go to your expert even if you don't have anything registered, but the Hague System is there to make that registration for you almost as easy as Madrid. And Andrea and Benoit, we've all said that there are sometimes local office requirements, but essentially to start you off. And on this point, I'll hand back to Helike to take over charge again. Helike, thank you for passing over to us inadvertently. She's gone again. I have jinxed her. Damn it. Okay, so another peculiarity, which I think is very, very interesting in relation to...
If I can interrupt you, Elliot.
Yeah, please, Benoit, go ahead.
We have 3 questions in the chat. And I think
since we have 15 minutes, I agree. So shall we now, if anybody, Joanna, Andrea, Helike, if you can hear us, if we can, and Nora, if we can go perhaps to going to the questions with 15 minutes to go, I think we should do that. Very good point, Benoit. I haven't got the chat open at the moment. Maybe, Benoit, you want to start us off by one of the questions or reading out one of the questions.
So it seems that Alexander has a lot of questions on this webinar.
That's good.
So that's already 3 questions. So 2 of them new. So the first one, anyone can answer, of course, but I think we already touched a bit the topic. Which countries have provision of deferral, delay of publication of design within or outside Hague System? So basically, we need a lot of time to answer this. We can answer for Hague, but maybe not for all countries in the world.
No. And the other thing is, Alexander, there are a number of good sources. There's indeed the one on the WIPO website where I give you some indication. We can certainly give you some general statements here. There is a table of the countries that go by the Hague rules and some which don't. So Benoit, firstly, over to you in terms of the Hague system. In fact, any one of the three of you, because you're more experts on that than I am, I can tell you what China does about it. But let's start, Benoit, with your experience on it.
First, I'm sharing something very useful from WIPO. You have all the member profiles. So basically, you take any country and you have all the information. It's quite simple to use.
You share that to host and panelists. You may want to share it also externally. Sorry. Thank you. I appreciate it, but I'm sure that Alexander would also like it.
Yeah, I didn't see. Thanks a lot. Yes. In terms of deferment, yeah, most countries, Southeast Asia, do deferment of publication. I was mentioning that there are some, let's say, limits in terms of the time. So I was mentioning Vietnam because I live in Vietnam, and basically we are following closely what is happening. And there were some amendments to the IP law in 2022. Now they're working on more amendments, and there will be, for example, exception of partial designs. But yeah, briefly, things are moving. And you really need to check country by country. Are they following the general rule? Do they have no deferment of publication, or do they have a limited period for the deferment?
Good. Andrea, what about yourself in your region generally? And again, this is really helpful. I think that you'll see a team that Benoit has again posted it in relation to select members and also the rules that apply. Andrea, what about your region generally in terms of deferment to be responding to Alexander's question?
Yeah, in Africa it's generally possible with some exceptions. In this case, not possible in South Africa, but the other countries like Nigeria and Egypt, yes. OAPI as well, 30 months. So it's generally the answer is yes, with some exceptions.
Okay, Joanna?
In the case of Latin America, it's depend on the country. Certain countries, if we focus just on Belize, Brazil, Jamaica, Mexico, Belize and Jamaica do allow for deferred publication, but Brazil and Mexico no. So that's 50-50 score there, and we could go on with the rest of the countries and will be a similar score.
Yeah, China will permit some deferment. The difficulty you've got there is if you've got deferment, then you don't have an enforceable right. I'm sure that's in other countries the case, because how can you enforce a right that other people do not know about? So this is one big risk that you got it. Also with design rights, because China does not formally, China will examine designs even when it comes through Hague as to formalities, but not as to content. Right. So in other words, they're not going to assess, and it's very hard for them to assess about the level of originality. By originality, I mean, what incrementally added to until you come to enforce those rights. So from that particular perspective, you've got to remember that deferment, at least in China, and I let others speak to their region or give us the finger up or finger down, it's really important when it comes to enforcement, because if you've deferred it, you don't have an enforceable right. At the time, sorry, until you publish it. Benoit, I guess it's the same for your region, right? Until you have a publication, how can people know about it?
Impossible. And we do have some countries where you don't even have online working system that people cannot be aware of what's happening. So yeah.
That's a really good point.
I see two more questions because the time.
Yeah, go ahead, Benoit. Next one.
And Helika is not yet back.
So Monica, which has got a very funny first name and surname. Monica, that's a great first name, surname. Monica.
So Monica, EU IPO, so maybe for Andrea, recently introduced major changes to design law. Do comparable rules exist in the jurisdiction you are discussing? And if so, how do they look in practice?
Well, if I
Andrea, over to you.
Can you hear me?
Yes.
Yeah, right. Thanks. I was saying that the short answer in this case, if I am asked, is no. African jurisdictions have not adopted the most recent EU legislation. Let's say the legislation in African countries is not comparable to the most recent adopted legislation in the EU. There are some maybe comparable effects that can be achieved in Africa is mainly in those countries that are part of the Hague System or part of regional organizations such as OAPI or ARIPO. But most national laws, especially I'm talking about big countries, big economies like Egypt, Nigeria, South Africa, Ghana, and so on. I would not say that it's comparable to the EU one.
Joanna, over to you.
The answer again is depend on the country, depending on the modification we're talking about. Like there's a lot of variables there, and again, it's a big region. We have to go assess all these questions by all the different rules, and in each of the countries, there's no one single answer for the region.
Similar for Southeast Asia.
And I was going to say, and I will very honestly tell you for China that I do not know of the changes at the EU law level, and this is why I've been 20 years in China. Thankfully, I can focus on one rather than the intricacies of EU law. So my answer to Monica is, Monica, I don't know. I can tell you that China had made the most recent changes to the design law were the ones implemented in June 2021. They've enabled and made it easier, as this team here knows very well, and Helika would also confirm, they've made it easier to protect things such as graphic user interfaces because of the partial design. You know, when you move, it used to be the case that you protected the GUI, and then if somebody moves the icons around, it's no longer protected. So those sort of changes have been brought in, an extension of the duration, as I mentioned earlier. Also, in terms of some of the formalities, the partial protection that I mentioned earlier, and also the way that they look at the design protection and interpret it has changed slightly, but I'm not familiar with the EU design law, recent practice and changes. So therefore, I must say, don't know. But the help desk, no doubt, if you have specific points, they'll be very happy to say, yes, this is same in China, or this is different in China, right?
And I think there is a newly published guide from European Help Desk on design protection for those interested.
There is exactly, and there are several guides also on the China EU IP SME Helpdesk as well on design protection, and that includes the changes that were made as recently as the middle of 2021. We've had a couple of additional questions, Benoit. The next one is also from Alexander. Alexander, wow! I hope you are not a young lawyer sitting behind the desk and we're finishing your project for you, but we're very happy to help out. SEA countries. Wow, that's a lot of countries. Poor Benoit. I'm so lucky. I'm only dealing with one country that's the most populous, but one jurisdiction. The answer to the question is $500 an hour, because that's legal advice. But I will give you the short version of it. The short version of it is it really comes down to the evidence that you have of the prior use and prior publication. So in other words, the way they would deal with it is, and I guess it would be same in Southeast Asia, but in China very quickly, is you would try to invalidate the design on the basis of that absolute novelty requirement. And for that, you would need to have sufficiently probative, that means convincing evidence of the prior publication. And indeed, the EU non-registered right would be a prior publication. Then again, as I said, I would usually prefer of notarizing. Now, most recently in China, you can use the Wayback Engine when you're looking at websites as they were 6 months ago, a year ago, etc. But the best way to do it is to go to a notary, to do screenshots or to take pictures of the product, go to the notary. Indeed, the very best way is to file a registered right in the EU rather than unregistered right. That's the best evidence of prior use, prior publication, prior art. But generally speaking, yes, you could. We would then look at it case by case and say, what evidence do you have? And would it be convincing to the CNIPA, the China IP office, to be able to invalidate that particular design that you find egregious?
For me, I can only add one word, is evidence also. So joining
evidence, right? What about Joanna? I guess the same for your jurisdiction, right? Key is about evidence of the prior publication.
Absolutely.
So we have different enabling laws, everybody, but ultimately they come down to the different regions. I mean, look at it. We've got Southeast Asia, we've got China, we've got South America, and I guess we've lost, I think, Andrea, but I guess he would confirm the same for Africa, apart from maybe South Africa.
I think we'll soon have to wrap up. I see last question, comments. One is again for Alexander, thanking you all of us for the discussion. Big question, enforcement in the countries. So yes, this is a big question for all of us. The second question
just
from
one sentence on that from each of us, Benoit, yourself and Joanna as well. The key thing here is always that you should, when you're filing your rights and you're documenting your use, that you already think of enforcement. Because otherwise, designs are a luxury that nobody needs if you can't enforce them. Benoit, over to you on this point. I guess you'd agree.
Sorry.
Go ahead.
Both of you. Either of you. Both of you. Please.
Go ahead, Benoit.
Go ahead.
Go ahead, Benoit.
Go ahead, Joanna. Sorry, Joanna.
You say you need to be thinking of enforcement with your design application, and I say any other right as well. Like if you're thinking of trademarks, it needs to be in alignment with your commercial strategy. It needs to be in alignment with your defense strategy. Where is worth to use a trademark that is not descriptive but not that distinctive? If you're gonna have to spend a fortune trying to defend it, like, come on, it doesn't make any sense. You need to be thinking registration, use, and defense beforehand. Together. It's all together. It's not an afterthought.
I would agree with it. Again, over to you, Benoit, for your comments on this point.
On the enforcement, well, most of the companies put money on protection, but then nothing happens in enforcement, from monitoring to sending cease and desist letters to taking action. So just my thoughts that you really need to set the whole IP protection strategy. It's like a full circle.
Yeah, and this
I'll add there. Sorry,
yeah,
I'll add there when it seems like when you say IP strategy, it seems like it's alien from the business. But here, to be honest, you need to be thinking business strategy. This is business strategy, not IP strategy.
The reason that this is significant here, though, and in this context, and the reason I separated it slightly, Joanna and Benoit, and the people listening in, is because there are differences and there are some elements of Hague that are not suitable for business strategy. For example, if you're filing a design in China, you can file background material. So in other words, you would file your 6 views plus perspective. Hague provides for all that, that's fine. But in China, you can file any number of additional images as background material, which are not formally defining the scope of protection. But when it comes to enforcement authorities, they still see that in the database. So that's the reason I was mentioning it, because in relation to filing in China, whether SME or somebody else, I would say you need to file the background material that gives you easier enforcement, because you may have additional pictures to allow the enforcement authorities to understand, especially if it's not, if it's a vase, we all recognize it. But if it's smaller or other parts. So from that perspective, if you have enforcement-oriented filing, then it may mean that in certain situations you can't use Hague and you have to use domestic filing to get the broader scope of protection. Benoit, does that apply to other jurisdictions, perhaps?
Sorry, I don't know. I was looking at Helika moving her head, and also the time running.
Very slowly moving her head. But Joanna, that's a very good point. It is not dissociated from business strategy. In fact, IP only exists to support business, but it may make the decision harder whether you go Hague or, for a lot of people to do PCT. But if you want double filing of patents, as you know, Benoit and Joanna, you have to file locally within Paris Convention. So the quick answer here is that The Hague has got a very important role. But always, as Joanna said, start with the business strategy and see how Hague fits into it, or whether you need to go some domestic filing for some jurisdictions.
Absolutely.
Well, maybe that's a good closing point for handover to Helika. We had one more question, did we, Monica? Monica, the quick answer to your question is yes, there is some scope to protect moving designs, although not formally, but you can do partial design protection. So at least in China, there is some scope, but really now you're hitting the cutting edge of design protection. And I'm not sure that that's what our Hague seminar was intended to cover, but it's a very good question. I like those. They make us think on our feet. Much appreciated. Helika, over to you to close for us before we lose you.
Can you now hear me, guys? Oh, great. So I'm back finally at the very end. I am really terribly sorry for these connection issues. Unfortunately, it is the evening time in China, and the use of internet is skyrocketing because everyone's getting off the work. Everyone's getting off the work, starting streaming when they are taking their subway to home. So unfortunately, that means I am losing out. Well, anyways, thank you for all of you IP business advisors joining today for this very interesting discussion session on the Hague system. And I would also like to thank everyone asking questions and making the past 15 minutes that I unfortunately had to miss still a very, very interesting discussion. And I think the key takeaway that we can take away from today's seminar is that design is important, and more important is to register it. As Giovanna said on numerous occasions, if you don't have your rights registered, you do not have your rights. And that means you might be losing out on investors. You will not be able to do anything if anyone copies your design. Well, there might be some options, but in general, you're not able to do much if someone copies your product. What we learned today is that different countries do have different laws and regulations when it comes to design registration and design protection. The Hague system is here to make the registration process easier. In Latin America, in Southeast Asia, in Africa, it does not necessarily apply for all the countries yet. We still have a bit less than 100 countries joining the Hague system. So it is important, even more important, to understand the requirements, regulations in each individual country that you are planning to do business in and that you are planning to register your design. Now, the help desks are here, the international help desk, so you can approach China help desk about China, Southeast Asia IP SME help desk about Southeast Asia, and of course Africa and Latin America. You can approach the respective IP help desk that can support you with explaining the rights, the regulations in a particular country or within the region. They can also explain where using the Hague system is feasible, or whether using the Hague system is rational. Is it feasible from your business point of view? So do reach out to the help desks before planning your internationalization journey, to learn more about design protection in the countries that you have as target markets. And with this, I think it is utmost time to finish today's seminar, and wish everyone good evening, good rest of the day, and thank you for joining in. Thank you. That's all from my side. Thank you, everyone. Iker, maybe final words. I see you're still with us.
Oh, nothing to add. Thank you very much. Just putting the camera to say hi to everybody. Yes. Well, have a nice rest of the day.
Elika, yeah. Thank you very much for persevering and for struggling with it. We know what the connections in China are like. I know because I know how much we pay to have a halfway reliable connection. Next time you come to China, you will see what Benoit, you've probably experienced it sometimes. Joanna, I hope you never have to experience it. It seems that the connective ability internally is fine. When you try to get externally, there's a limited scope. So Elika, thank you for enduring. And everybody who stayed with us, thank you also very much. We have a couple of hiccups, but at least you know we're coming live from China.
Thank you.
Thank you. And I guess Nora can cut the webinar here. And thank you. Bye-bye, guys.
Bye, guys. Thank you, Benoit. Good to meet you, Joanna. Elika, as always, a pleasure.
Bye.
Nora, viszont hallásra.